So with the Supreme Court overruling Roe v. Wade, it seems like now is a good time to talk about what all the fuss is about. Let's talk about it in today's video. Hey, I'm Mike Greiner. I'm a lifelong Democratic activist who's concerned about the direction our country is taking. I'm also a lawyer and an academic, and I'm here to help you stand up to the BS of the MAGA crowd. So the other day, as news came across the various media sources talking about the fact that the Supreme Court had, in fact, overruled Roe v. Wade, both my daughter and my wife came to me with questions about what this means. And I figured, if they came to me with questions, I can only imagine that a lot of you folks out there might have questions. So I wanted to kind of do a little bit of a primer about what the abortion debate is all about and how the different legal machinations affect each other. So before we get started, it's important to kind of point out one legal concept. And what it is that we've got something in the Constitution that specifically says there can be no ex post facto laws. So what that means is, if something is not specifically banned by the law, it's legal. They can't later on go and add a provision to the law banning some behavior and then go back and prosecute someone. So in places where the law says nothing, abortion is legal. For abortion to be illegal, the state needs to specifically pass legislation making it illegal. Now, as it turns out, by the early 1970s, pretty much every state in the Union had made abortion illegal except for Alaska, California, Hawaii, New York, Washington, and Washington, D.C. And in fact, it was not uncommon for women to be charged with manslaughter or even murder for terminating their pregnancies. But it's important to note that really up until the 1840s, abortion up until what's called quickening, which is essentially during the second trimester that it occurred, that abortion during that period was generally legal. So it's not like it's something that dates back to the very beginning of this country in terms of it being illegal. But certainly by 1971, most states had banned it. And that's what gave rise to Roe v. Wade. Now the plaintiff in the case, who's referred to as Jane Roe to protect her privacy, but her name is actually Norma McCorvey, was from Texas, and in 1969 she became pregnant with her third child, and she wanted an abortion. But because of the fact that she lived in Texas, it was illegal. Thus arose this lawsuit. Two attorneys, Sarah Weddington and Linda Coffey, filed her lawsuit against Henry Wade, who is the local district attorney, arguing that he should not be able to enforce this ban against her because of the fact that it was an unconstitutional law. Interestingly enough, the district courts, the lowest level of the court, ruled in favor of Jane Roe, or Norma McCorvey, in the initial case, but it kept getting appealed all the way up to the Supreme Court, which is where, of course, it got resolved. Now, ultimately, the decision was handed down in 1973, and it was a 7-2 decision in which most of the justices voting for protecting abortion as a right under the Constitution were appointed by Republicans, including, by the way, Harry Blackmun, who drafted the opinion. Now, this case was not decided in a vacuum, and it's important to kind of point out that Supreme Court jurisprudence had been heading in this way for a long time. For example, in 1965, the court ruled in Griswold v. Connecticut that states could not stop married couples from getting birth control. So the idea is that deciding whether to have children or not is something that's a private matter that should not be regulated by government. Similarly, in 1967, you have the case Loving v. Virginia, one of the best named cases ever in my opinion, where you have an interracial couple from Virginia suing to have laws declared unconstitutional that banned people from marrying people of different races. Those laws were fairly common in the old Confederacy. And so when Loving v. Virginia was decided, essentially it said that, hey, being able to decide who you want to marry, that should be something that's private, and the state doesn't really have an interest in that either. So you can see where these decisions then would lead to later decisions. So for example, Loving v. Virginia, you can see if the court says, hey, you can decide who you want to marry, that leads inevitably to Obergefell versus Hodges, which is the case that declared gay marriage legal across the country. Similarly, Griswold v. Connecticut, which stated that people can decide whether they want to have children or not, and the state shouldn't get involved in it, inevitably led to Roe v. Wade. Now, the arguments that you hear all the time from conservatives about this is, well, abortion isn't stated anywhere in the Constitution, and they're right. But guess what else is not stated in the Constitution? The Air Force, and yet we have an Air Force. Isn't that amazing? And that's the point, which is that the Constitution was a document drafted back in the 18th century, in the Enlightenment era. Things have happened in our society that they never could have imagined, and it was drafted with an eye to the issues that they were dealing with at the same time. So, for example, one of the early rights that's guaranteed in the Bill of Rights, specifically the Third Amendment, is that the government can't require you to quarter soldiers in your house. Well, why was that an issue? That was an issue because the British government used to quarter soldiers in people's houses without their permission, and people didn't like that. So they included that in the Constitution then. But it's important to note that there are lots of things that are not included in the Constitution. In fact, the Bill of Rights, which includes such fundamental rights as freedom of speech, the right to bear arms, that's the Second Amendment, and the right to be protected from unreasonable searches and seizures, those were actually amendments that came after the original Constitution was drafted. The original Constitution itself was basically an economic document, drafted because of the fact that at the time, the United States was basically this loose group of states, a confederation they called it, and that this confederation, they kind of couldn't coordinate things. So the aim of the Constitution was effectively to create some central power that could regulate commerce and provide for the military. And that's it. What's more is the state's fear was really that this federal government would get too powerful, that it would step in and kind of mess with their stuff. So a lot of the Constitution is designed in a way to kind of limit the power of the federal government. In fact, if you look at the Bill of Rights, it doesn't say in the amendments that the right to freedom of speech is protected as a fundamental right. Instead, what it says is Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech, etc., etc., etc. Congress shall make no law. So actually, the Bill of Rights is not about guaranteeing each individual rights. The original Bill of Rights is about guaranteeing the states' rights. It doesn't say the states can't do that. It says Congress can't do it. And really, it wasn't until one of the amendments resulting from the Civil War that these rights were then expressly given to the individuals as well. So we have an old document that's changed over time and has been interpreted in various ways, no matter how the conservatives want to claim it. Because if they want to claim that if something's not in the Constitution that's not within the power of the federal government, well, we have to get rid of our Air Force then, right? And I think everybody would agree that's an absurd result. So the argument that if it's not in the Constitution, it isn't legal is absurd. But obviously there has to be some basis for it. And the basis is this idea of substantive due process. Now, due process is the idea that you need to get notice before a court can hold a hearing. A court can't make a decision unless you're given an opportunity to plead your case. Now, that idea of due process is enshrined in a couple places in the Constitution. But the idea of due process seems very procedural, right? You know, the court just needs to make sure that both parties are there and have their chance to kind of freely plead their case before the court can make a decision. But at some point, legal scholars realized that due process actually protects something, that there's kind of this area around the individual that is protected and the state can't step in, and that's why we have due process. And the fact that there is this area around the individual is something that came to be known as due process. Now, ironically, this idea first came up in court decisions in a case called Lochner v. New York in 1905, and the people who brought it were conservatives, actually. In fact, what that lawsuit did is strike down a law that limited the number of hours that bakers could be required to work in New York. You see, you have to understand, there are only two rights that are actually specifically guaranteed in the body of the Constitution itself. And what those rights are is the right to property and the right to contract. As I said, the Constitution was originally an economic document. So what Lochner held is that you couldn't pass a law that would violate people's right to contract. And somehow by passing this law limiting the amount of hours that a baker could work, you were getting in the way of this freedom to contract. Now, this judicial philosophy became a big problem, especially when we came up to the New Deal in response to the Great Depression. This philosophy was routinely trotted out to strike down things like minimum wages and laws against child labor and that type of thing. But what happened in 1937 then, after he was first reelected and after he'd seen the Supreme Court strike down some of his New Deal legislation, President Franklin Delano Roosevelt essentially threatened to expand the size of the court and add new members to it, and in so doing, change the ideological makeup of the court. Now, as it turns out, FDR kind of ended up getting a very negative reaction to his idea, and it was called court packing. But ultimately what happened is a couple of the justices ended up kind of shifting their position on these issues, and as a result, they allowed much of the New Deal to actually go through and to be found constitutional. In fact, the first law that was upheld under this changed regime was the NLRA, the National Labor Relations Act, which dealt with, of course, unions. Now, it's worth noting that FDR's idea didn't come out of nowhere. I mean, the court at the time did have 9 members the way it does now, but that was not always the case. The number 9 was kind of randomly selected in 1869, and this was actually, it was changed a couple times very rapidly by Congress because they were trying to limit the power of Andrew Johnson, who had been Abraham Lincoln's vice president, came into power, of course, after Abraham Lincoln's assassination. But before that, the size of the court ranged anywhere from 5 to 10 members. And in fact, the size of the court is not set by the Constitution. The Constitution simply says that there shall be a Supreme Court and nothing more. And in fact, this idea of judicial review, in which the court decides whether certain legislation is constitutional or not, is also nowhere in the Constitution itself. In fact, that dates back to an opinion that came later that's called Marbury versus Madison, which was handed down in 1803. So what happened after this Lochner era came to an end, where substantive due process was used as a way to strike down progressive laws, is the idea was revisited in the 1960s. When the court said, okay, there's this area around the individual that's protected by substantive due process. And what this area around the individual is their privacy, that the people have their rights to make their own decisions without the government getting involved. And that's what then led to Loving v. Virginia, Griswold versus Connecticut, and ultimately Roe v. Wade and Obergefell versus Hodges. So once the Supreme Court in 1973 announced that abortion was protected under the Constitution, under this idea that we have a privacy right guaranteed to us under the Due Process Clause of the 14th Amendment of the Constitution, it basically made laws across the country which banned abortion illegal and irrelevant. Now, many states ended up getting rid of those laws. Some states, however, did not. And in fact, here in Michigan, my home state, we have a law that dates back to 1931 that bans abortions even in the cases of rape and incest. It's a complete ban of abortions. So essentially that law became irrelevant when Roe v. Wade happened because Roe v. Wade said that law doesn't have the power. They can't do that anymore. Now that doesn't mean that the law wasn't there. It just meant that it wasn't in power anymore. Now what ends up happening, now that the Supreme Court has declared that abortion is not protected by the Constitution, all of a sudden these laws that have essentially been dormant suddenly became alive again. And in fact, there are a number of states, including, again, my home state of Michigan, Wisconsin, Arizona, and Indiana, to name a few, where there were laws in effect banning abortion in one way, shape, or form prior to Roe v. Wade that then became dormant while Roe v. Wade was in effect. Those laws now become effective. Now here in Michigan and Wisconsin as well, for example, you've got Democrats who hold statewide elected positions. The legislature in both states are held by Republicans, largely as a result of gerrymandering. And in fact, if the legislature in these states reflected the way the state voted on a partisan basis statewide, you'd have Democratic legislatures in both states. But hey, you've got gerrymandering, so there you go. So as a result of it, there's no way for us to get rid of these laws because of the fact that these Republican state legislatures are committed to keeping them in effect. But because of the fact that you've got statewide elected officials who are Democrats, they've taken the position that they are not going to enforce these laws. And in fact, here in Michigan, Governor Whitmer has taken some very aggressive steps, essentially asking the state Supreme Court to declare abortion a right under the state constitution. Because you have to remember, we've got state Supreme Courts that rule on the state constitutions the same way that the federal Supreme Court, the U.S. Supreme Court, rules on the federal constitution. My guess is that effort will not be successful, but at least we have to be thankful here in Michigan for the fact that you do have elected officials who are going to refuse to enforce these bans on abortion. The problem is what happens when someone else comes into office. If the Republicans were to win the governorship and the attorney general here in Michigan, it's certainly possible they could start to enforce that law. Same thing in Wisconsin, for example. Now, in addition to the states that have these dormant bans, you've got states that subsequently passed legislation specifically aimed at overturning Roe v. Wade. Examples of that, of course, would be Texas and Mississippi, for example. Both states that sent cases up to the Supreme Court that ultimately led to this decision. Those are more recent laws, and in some respects, they're not quite as harsh as the laws that were dormant because of the fact that they were specifically aimed at just doing enough to violate Roe v. Wade without somehow repelling the Supreme Court justices. It was more of a political decision rather than a legal decision. Now, on top of that, then, you've got states that say nothing about abortion. And again, saying nothing means it is legal, or states where they have specifically allowed abortion. And those states at this point appear to be Alaska, Colorado, Illinois, Maine, Massachusetts, Minnesota, Nevada, New Hampshire, New Mexico, Rhode Island, California, Connecticut, D.C., Delaware, Hawaii, Maryland, New Jersey, New York, Oregon, Vermont, and Washington. And it's ironic, of course, to see Connecticut on this list because, of course, it was one of the first states to actually ban abortions. And what's more is it was the state that had banned the sale of birth control, leading to the Griswold v. Connecticut decision. But yet here it is on the list of states that will protect abortion. So where do we go from here? Well, you're going to see basically the country divide up into two groups, with a third group in the middle. There's going to be one group of states that are firmly pro-choice, one group of states that are firmly anti-abortion. And then you're going to see states, again, like Michigan and Wisconsin, that are kind of somewhere in the middle, where you're going to see a battle going back and forth between the Republicans and the Democrats, in particular, to see whether abortion is going to remain legal here. Now, that kind of uncertainty is exactly what makes medical providers nervous about providing abortion, because who knows when things could change or when this could become a different. And as a result, one of the largest hospital systems here in Michigan, the Beaumont Hospital System, I just read this morning that they've just declared that they are not going to perform abortions anymore. So you can see how this effort kind of eats away at the right to abortion, even in places where it remains a right, at least for the time being. So what can be done about this? Well, the sad truth of it is, it's likely that the Supreme Court is going to remain with this partisan makeup for the foreseeable future. Even though President Biden just appointed a new Supreme Court Justice, Ketanji Brown Jackson, she's replacing Stephen Breyer, who is another of the liberal members of the Supreme Court. And the 5 justices who comprise the extreme right wing of the court are just getting started. In fact, in his concurring opinion that he filed in support of this ruling, Justice Clarence Thomas specifically said that other rights that have been protected by substantive due process should also be reconsidered by the court, including things like the right to birth control and the right to gay marriage. And I find that statement rich, given the fact that he is actually married to a white woman, an arrangement that would be illegal were it not for the ruling of Loving v. Virginia under a substantive due process theory. So the hope is that President Biden might have the opportunity to appoint a couple more justices to the court, which might change the dynamic there. Unfortunately, the odds of that happening right now are slim. If the Republicans take Congress, for example, they've made it clear they're not going to allow President Biden to appoint any new justices, even if a position becomes available. But what's more is President Biden could potentially make a move to increase the size of the court and implement a plan like Franklin Delano Roosevelt was trying to implement to try to make the court more responsive to the needs of the country. That type of move requires only 50 votes in the Senate, with Vice President Kamala Harris being able to break the tie. The problem, of course, is the filibuster, which, thanks to the intransigence of Joe Manchin and Kyrsten Sinema, means we can't pass anything without getting 60 votes in the Senate, which is impossible right now. So what's the message of all this? The message is that we need to elect more Democrats in the next election. There's been a whole bunch of progressive legislation that has passed the House, which has been under the control of the Democrats and with the leadership of Nancy Pelosi as Speaker. Indeed, they've talked about passing legislation that would protect the right to an abortion. The problem is all this legislation goes to the Senate and dies there because of the fact that we can't get the 60 votes to overcome the filibuster. So how do we deal with that? Well, if we're able to hold on to the House and we're able to gain 2 more members of the Senate as Democrats, something that's highly doable, and making sure that all our current senators are reelected, then that would give us the leeway to be able to vote to overcome the filibuster without relying on Joe Manchin and Kyrsten Sinema. And my hope is that one of the pieces of legislation that would pass would, of course, be protecting the right to an abortion. And another piece of legislation that would pass would be something expanding the court, allowing Joe Biden to appoint some new justices who will more accurately reflect the needs of today's America. So I have to leave this on a hopeful note. We have to get out there and elect more Democrats. It's our only chance. Because if we don't, unfortunately, this Supreme Court is going to continue to run roughshod over our rights and to enforce their tyranny of the minority. Well, if you like this video, why don't you check out this other video over here that I did where I talk about just how political the Supreme Court has become. I'll see you then. In the meantime, let's hope for continued progress. Thank you.